afternoon. I'm Mai Fernandez, and I'm the Executive Director at the National Center for Victims of Crime. Thank you all for being on our webinar this afternoon. We're very excited to have a very timely discussion on smartphone encryption and the impact on victims. This is being done for us and in partnership with the New York County DA's office. And on the webinar, we have Ken Kern, who is the Chief of Staff of the Investigation Division at the New York County District Attorney's Office. Ken joined the office in 2004 and initially served in the Trial Division before transferring to the Major Economic Crime Bureau in 2009. In 2011, Ken was appointed Deputy Chief of the Cyber and Identity Theft Bureau, prosecuting and supervising a wide variety of complex financial, identity theft, and cyber fraud crimes. Ken is an honors graduate of the University of Texas School of Law, and we're very happy to have Ken on the webinar today. We also have Diem Tran, who works at the Legislative and Policy Office for the DA's office in Manhattan. Prior to joining the Manhattan DA's office, Diem worked at the New York State Senate and at the international law firm of Weil, Gotshal and Manges. She received her undergraduate degree at the University of Pennsylvania and received her law degree from the University of Virginia School of Law. Thank you for being on the webinar today, Diem and Kern, and I leave it up to you to start your presentation.
Thanks, Mai. Thank you very much. We want to start by thanking the National Center for Crime Victims for organizing this webinar, and thank you to everyone for participating today. We just want to start by giving a brief overview of why it's so important for law enforcement to access evidence contained on smartphones. Many of you probably have on your desk right now a smartphone. Most of us live our lives on smartphones. This is where we keep our calendars and contact lists, where we store photos and videos, and how we can communicate using text messages and iMessages. Criminals are no different. Nearly every criminal case, from robbery to sex crimes to murder, now has a digital component. The evidence that used to be stored in file cabinets and ledgers is now stored almost exclusively on smartphones.
Prior to September 2014, when law enforcement wanted to access evidence of a crime on a smartphone, just as we do with any other type of evidence, we went to a judge. So whether it was a sex crime, a homicide, a cyber-related matter, the path is always the same. It goes straight to a judge who has to find that there's probable cause, that there's evidence of a crime on a device, and then he or she will issue a search warrant. This has been the standard set by the Fourth Amendment of our Constitution. In addition to that search warrant, we also obtained from the judge an unlock order, which directed Apple to unlock the device. Again, this is prior to September 2014. We would then send an investigator with that device to Apple's headquarters in Cupertino, California. Apple extracted the evidence specified in the warrant and sent that evidence back to prosecutors. I want to emphasize something very important. At no point during that process did prosecutors ever learn or obtain Apple's method of unlocking the phone. Our office and every other office around the country that follows the same approach had no access to Apple's intellectual property. Apple held the key, not law enforcement. And our prosecutors and investigators never gained access to the unlocked device itself, only the data that was specified in the search warrant. Things changed in September 2014. Apple chose to change their newest operating system, iOS 8, to be fully encrypted by default and inaccessible even to their engineers. So this is important. Even Apple could not unlock the phone.
So Apple's decision to move to default device encryption was made seemingly overnight, and they did not notify law enforcement about this decision. This is how Apple explained the change on its website after the fact. Quote, Apple will not perform iOS data extractions in response to government search warrants because the files to be extracted are protected by an encryption key that is tied to the user's passcode, which Apple does not possess, end quote. Shortly after that, Google announced that they would follow suit.
Since Apple's decision at that time only impacted devices running iOS 8, the scope of the impact of default device encryption was not immediately apparent. But as more users updated their software and upgraded to new devices, law enforcement began to be locked out of more and more devices. As of February 2016, Apple reported that 94% of their devices worldwide are running iOS 8 or 9. That means that Apple engineers cannot access the data on 94% of those devices, regardless of whether the request for data came from law enforcement or from the device owner themselves. As a result, digital evidence on almost all Apple devices is now beyond the reach of law enforcement agencies who possess a valid search warrant issued by a judge.
As you mentioned earlier, digital evidence is found in every type of criminal case. This graphic shows the type of criminal cases represented by the smartphones that come through our office's cyber lab. As you can see, it spans from white-collar crimes such as cybercrime and identity theft to violent crimes such as homicide and sex crimes.
District Attorney Vance knew that default device encryption would become an issue for law enforcement almost immediately upon Apple's announcement. He made the issue a priority for our office and directed us to start tracking affected cases, to conduct research, and to reach out to other agencies, legislators, and victims advocacy groups. In November of 2015, Mr. Vance released a white paper that outlined our understanding of the issue, its impact on investigations, and a potential legislative solution. The New Yorker called it, quote, the most thorough report on the subject of encryption. And you can read the white paper on the Manhattan District Attorney's website.
As the encryption debate became more public, we began seeing our office's position being mischaracterized and a number of myths being repeated. We continue to see these mischaracterizations in news stories and hear them in conversations with legislators, government partners, and victims organizations. DA Vance wrote an op-ed in the Washington Post to attempt to clarify our office's position. An excerpt of that piece appears on this slide. We would like to further dispel some of these myths as part of today's webinar.
So let's start with myth number one. We want to ban encryption and weaken smartphone security. Nothing could be further from the truth. The Manhattan District Attorney's Office handles more cybercrime and identity theft cases than any other jurisdiction in the country, so we truly understand the importance of encryption. But despite District Attorney Vance asking Apple and Google several times, they still have not explained why the prior operating systems lacked security. And they have not explained what security risks new operating system actually protects people against. For example, Apple's default encryption on smartphones would not have protected against large-scale institutional hacks that we've seen at companies such as Home Depot and Target and many other these type of attacks throughout the world. And Apple's default smartphone encryption would have prevented, not in any way, NSA's bulk data collection.
And speaking of the NSA, myth number two, that law enforcement wants to be able to conduct warrantless searches of these devices, just like the NSA did for years. As we noted earlier, we only seek to obtain data on smartphones with a warrant issued by a judge who has found that there is probable cause that evidence of a crime exists on that phone.
Myth number three, certain places have always been off limits to law enforcement. Law enforcement just wants to make its job easier. It couldn't be further from the truth. iPhones are the first warrant-proof consumer product in American history. The technical companies have made our ability to keep the public safe drastically more difficult. We are not looking for shortcuts. We are looking for critical evidence of crime, and more that critical evidence is stored on smartphones.
Myth number 4, data stored on smartphones can be obtained elsewhere. We go into a bit of detail in our white paper regarding this, but the short answer is that because so much of the information we store is now on our smartphones, it has become very difficult for prosecutors to obtain evidence stored elsewhere.
Myth number 5, police and prosecutors don't really need smartphone data to keep us safe. Many defendants, particularly those who commit sexual offenses, take photos and videos and store them on iPhones. Our office has continuously relied on evidence stored on smartphones to convict defendants in a host of different cases, including murder, assaults, and white-collar crimes.
In addition to prosecuting the guilty, evidence stored in smartphones are also important for exonerating the innocent. One of our jobs as prosecutors is to make sure, to the best of our abilities, that we are prosecuting the right person. Often, smartphone evidence can be used to support alibis, clarify timelines, and provide other evidence that may contradict other, less exact forms of evidence, including witness identifications, circumstantial evidence, and cell phone metadata.
Our efforts began tracking devices and affected cases in 2014. And as of February 2016, our cyber lab has received, at this point, 215 devices that are completely inaccessible. We did a count again and a review to the end of March, and that number jumped up to 229 devices that remain inaccessible to our office and our investigators, despite the fact that a judge has signed a warrant for all of those. I want to point out that that number, 229 devices, that's only our office's lab. It doesn't include hundreds of other devices that are sitting in our New York Police Department cyber lab or obtained by district attorneys in other New York City boroughs. I'm only talking about one borough, Manhattan, one office, the Manhattan District Attorney's Office, and our lab.
So far we've talked a lot about the impact of default device encryption on our ability as prosecutors to investigate and prosecute crimes. But we think that a voice has been missing from this debate, and that's one that we feel is the most important, that of victims of crime and their families. One of the more widely publicized examples of the impact encryption is having on crime victims comes out of East Baton Rouge, Louisiana. This picture is of the victim, Brittany Mills, and her mother, Barbara Mills. Mrs. Mills has been advocating to get justice for her daughter and grandson.
Brittany Mills was 8 months pregnant when she was fatally shot inside of her home. Her unborn baby died 6 days later. Here are some of the facts. It was a Friday night and Brittany was home with her 9-year-old daughter. Her daughter said she had been on her iPhone all day texting. There was a knock on the door and Brittany went to answer the door. Seconds after she opened it, she was shot multiple times and killed. There were no witnesses, there's no surveillance footage, there was no trace of who came to Brittany's house that night. Her family believes she knew the person, and investigators believe the person was asking to borrow her car. Brittany used her phone for everything from texting to web browsing to actual phone calls. Investigators believe that there is evidence of who came to borrow her car that night on her iPhone. Sadly, this double homicide remains unsolved.
In the past couple of months, this debate has been rebranded as Apple versus FBI as a result of the federal court case in San Bernardino, California. There, the FBI was unable to access data from one of the deceased terrorist's iPhones. On February 16, a magistrate judge in California ordered Apple to help the FBI gain access to that phone. In a response, Apple CEO Tim Cook posted a 1,100-word open letter on Apple's website, vowing to fight the order and defending the company's move to default device encryption.
But as the debate took on a more federal focus, District Attorney Vance and New York Police Commissioner Bill Bratton spoke to reporters about the unique concerns of state and local law enforcement and how this issue of encryption affects crime victims every day at the local level. And we're not talking about a fringe position. Government officials have made statements supporting the position of state and local law enforcement, from our mayor here in New York City to elected officials all across the country. This includes President Obama, who recently said that preventing law enforcement from accessing evidence on smartphones is, quote, fetishing our phones above every other value, and that can't be the right answer, end quote. All the presidential candidates on both sides of the aisle have called on the tech community to work with law enforcement to try to find a solution.
DA Vance strongly feels that in this contentious debate, the voices of victims and victim service providers have not been adequately heard. So going forward, there are several ways you can help bring the perspective of victims and their families to the forefront. Number one, provide case examples about the importance of smartphone evidence in cases affecting victims across the country. Number two, reach out to Apple and Google and express the perspective of the victims and their families. Number three, write op-eds or open letters. And four, discuss this issue with your elected officials and community leaders.
As DM noted, op-eds are critical. Safe Horizon, for example, penned an excellent op-ed in the New York Daily News about the impact of default device encryption on victims. And we are asking, it'd be wonderful to see more victim service providers speak out on this issue as you become more comfortable with it, because you serve such a useful role in educating the public about the perspective of victims and their families in this debate, a debate that right now has been primarily focused on national security at the federal level.
Just this past Monday, we held a press conference in New York City with about 10 victim service providers, as well as Mrs. Mills and her family, to highlight the importance of smartphone evidence to crime victims. If you would like more information, our website has links to a number of useful resources. And of course, you can call or email us at any time. We're happy to take any questions.
Thank you so much for your attention. We look forward to any questions that you might have.
Ken and DM, thank you very much for that presentation. We do have a question that's up right now, and it's newer iPhones include biometric finger readers. In a case like Brittany Mills, could her thumbprint be used with the permission of the family to solve a case and others similar to it?
So each state is very different in terms of its laws, and District Attorney Hilar Moore, who is handling that investigation in Louisiana, has explored every avenue possible that the state of Louisiana permits him to, from fingerprints and across the board. And sadly, he was just here with us last Monday, and that device is still inaccessible to him.
I think with regard to the fingerprint, it also requires a warm body. So unfortunately, in Mrs. Mills' case, it just, once the phone is found, her daughter's fingerprint was no longer useful.
Another question. From your point of view, is it your understanding that Apple can unlock each phone individually?
So just in terms of timeline, up until September 2014, that absolutely was the case. They could go ahead and receive the phone in Cupertino along with the search warrant, and phone by phone, warrant by warrant, and remember the phone and the warrant always go together, they could access that device. But right now, their public position is that they cannot themselves access it, and any device that we would try to send to further our investigation and our process, they cannot get into.
Thank you. Okay, the next question. This is, you may or may not be able to answer this. Do you know the status of Apple trying to force the FBI to reveal how it broke the encryption in the San Bernardino case?
Yeah, so I can speak to it based on publicly available information. Apple has made informal and formal requests that the FBI provide the answer to that 5C. The device in San Bernardino was an Apple 5C, and that the FBI was able to get into. Just some, in terms of numbers, that device is unfortunately not the type of the devices that we're seeing come into our offices and offices throughout the world. So the Apple 6s are really the volume of what's coming into forensic labs all around the country. At this point, Mr. Comey has indicated publicly that he has not disclosed it to Apple, and it raises a larger question about what Mr. Vance has said is the last thing that we want to do is engage in a technological arms race between Silicon Valley and government agents. You know, as law enforcement, we've taken an oath to try to investigate, exonerate, and prosecute. And we should not be in a position where, you know, hackers are being hired, patches are being made. There's a legislative solution that really is the best way forward. The most logical approach here is out of the U.S. Congress.
Thank you, Ken. Our next question is, what do Apple and Google have to gain from not cooperating with law enforcement?
Well,
yeah,
I think you would have to, you know, ask Apple and Google, but from our perspective, it is a marketing strategy. I think after the Snowden revelations about the NSA, there was a big public outcry about privacy, and they seized on that. They essentially seized on the fact that customers want privacy. But what they did was they conflated several issues. They conflated the NSA with local law enforcement. And, you know, without knowing the nuances and of how law enforcement goes about doing our job, all of these nuances are lost on the public.
You know, it's one of these things that no one here is saying anything untoward about Apple's employees, and, you know, we recognize that just those employees at Apple and other Silicon Valley companies, they have families, they worry about public safety. These are good people. When that change was made, the logic of what would happen, the unintended consequence of a downstream effect for us at the state and local level, I'm not sure if it was ever contemplated that there would be this many devices all around the country on rapes, robberies, cybercrime, that local law enforcement, state law enforcement, federal law enforcement couldn't get into. Again, when a judge's warrant is signed, this always has to be framed as, it's not prosecutor's order, it's a judge's order who's reviewed the balance of privacy concerns and the balance of investigation related to a particular case.
And as Ken mentioned it earlier in the presentation, prosecutors never actually have, we don't actually get the unlocked phone. We get the data from Apple regarding what's on this search warrant. We don't actually get access to the unlocked phone itself.
But regretfully, you know, right now, Apple stands alone in terms of us and our ability to get into devices. You think of other industries, hospitals, financial institutions, other telecommunications firms. When a judge signs a warrant, they have to turn over data. Apple has made the first warrant-proof device, and all the phones that we have a judge's warrant attached to it. It's just become meaningless right now.
Thank you. The next question is a more appropriate solution educating the consumer, perhaps backing up phones to a place that can be accessed in case a person is a victim, similar to a living will?
I think it's absolutely it's a great question, and I would say yes. We want as much backing up as possible. Now, there are some barriers to that. Backing up costs money. People have to make sort of strategic choices with their dollars. But here's another thing. When people do back up to the cloud, there's information on the cloud that if I get a warrant for it through a judge, and that judge signs off on an iCloud warrant, I may not get things like iMessages. Now, why is that important? For our investigation, it often matters not just that people were in a conversation, but what they actually said. So there's things on the cloud that, one, are unavailable to us even with a warrant, and number two, some of those things are actually encrypted. So we go and get a warrant for the cloud, and it puts us in the same position. But the education part is a terrific point, and there should be more and more education about trying to make sure people do make these choices.
Also, so Facebook, for example, allows its users to provide access, after they die. Apple does not have that option for its users.
And just one quick addition. We deal just like every other law enforcement. We sometimes have criminals who are dumb, and sometimes we have criminals who are really, really smart. And the ones who are in a wide range of crime, one, they know that this device now, law enforcement cannot get into it. And number two, if I'm a criminal and I'm trying to hide information, the last thing that I'm going to try to do is move it off the device into the cloud. I'm trying to narrow where that evidence is going to be so that I don't get caught red-handed.
This is probably somewhat of a follow-up. Since Apple put the encryption on the phone, can't they just take it off? And my sense is if I personally want it off, can I ask Apple to take it off?
No. So it's right now, according to Apple, if you're running the newer operating systems, if you lose your passcode and you haven't given your passcode to anyone else, you will not be able to access it, and Apple will not be able to access it. It's completely inaccessible without the passcode.
Okay. Our next question is, if they wrote the backdoor key, would they maintain that instead of going to law enforcement? People do not trust the FBI, the NSA, and do not want a backdoor key to exist because the NSA and the FBI have been hacked. DV victims also want to secure their smartphones against their perpetrators.
Yeah, great point. Let me start by saying this office and other law enforcement offices throughout the country, we have never held a key. We have at no point had access to any of the intellectual property that Apple has in Cupertino. We wouldn't even be allowed to set foot in their area. This is very important to note. The second point is that in terms of backdoors, no one here is trying to push a particular solution. What Mr. Comey has said is that Apple and Silicon Valley, with all the significant wealth of intellect and ability and technological prowess, should be able to come up with a way to balance the two competing demands of privacy and security, as well as take care of its obligations to the law enforcement community. So that has been the request. When Mr. Vance met with Apple, he saw this problem and immediately went to California to have a conversation, to look for a common solution, to see if there was a path that once Apple was aware of the impact this was having on victims in our world, you know, what could be done? Sadly, there's just been no proposal back from Apple to say, we recognize that the situation that you're in trying to investigate cases, here's a path forward. So we're looking, we need solutions from Silicon Valley. And that's what the legislation that Senator Burr and Feinstein have put out calls on each individual company to come up with its solution and path forward. When they're handed a warrant, they can figure out how to go about turning over that evidence.
Question. Once a phone is sold to a consumer, it is no longer Apple's property. So why should they be compelled to maintain a backdoor into the person's private property?
Well, you know, it's one of these things where it's a societal choice. Let me just frame it this way. Every financial institution wants to be out of the business of responding to a subpoena by a law enforcement that's signed by a judge. Every hospital would love to be able to cut out its obligations to society to turn over data and records. It is at times difficult, but you know, it's one of these things that Apple has the financial bandwidth to be able to do what every other company in this world has the ability to do, which is when a judge signs off on an order to go ahead and meet the demand. We as a society have said that there are times when the risk to a person or a case or an investigation is so important that a judge says he wants or she wants to pierce and turn over materials. So Apple shouldn't be the only one in the world to be exempt from this responsibility.
And with regard to the user's iPhone as being that person's personal property, as Ken had mentioned earlier, smartphones are now the only piece of property that law enforcement can access without a warrant. I mean, right now, something as private as a person's home or even the person's body can be pierced with a judge's court order. And we view the iPhone as no different.
And Apple happily and provided and has said it was a good partner to law enforcement all the way through 2014. It publicly touted how important its relationship was to law enforcement throughout the world. And when it received a judge's order, out of our building here, 36 judges all signed various orders over various cases. They complied because they recognized they have a societal obligation beyond just their financial bottom line.
Do you have any suggested talking points for those who are critical of victim service organizations taking a stance against encryption because they feel encryption protects victims/survivors from abusers spying or keeping track of them?
Well, I think the slides in this presentation would be a good starting point. I think with regard to victims' concerns about abusers and stalkers, I mean, that's a matter of just a passcode. I mean, the victim, with or without Apple's new operating system, if the victim's stalker or abuser has the victim's passcode, they're going to be able to get into that phone. It's just a matter of being able to obtain that passcode. I mean, with the new operating system, it doesn't change the ability of the defendant or, you know, of the stalker to be able to get into that person's phone with the passcode. It doesn't protect against the person, you know, it doesn't protect against that victim.
do you have, DM, with regards to that question, do you have a set of reasons why victims are safer with y'all's ability to get into a phone?
Do we, well, our ability to investigate and exonerate cases, we have plenty of those, and we're happy to share any of these. And again, it's important to reiterate that this process also, when we're able to get into a device, we're often able to say that an individual who was wrongly accused, the record is now straight, and we're able to use that to free that individual from wrongful accusations. But we definitely have examples in which the evidence off of smartphones has helped us to be able to protect victims. That goes across the board, from individuals who are, who have been victims of sex crimes to domestic violence. It is a rare case in our criminal justice system where we are not using evidence from a smartphone to investigate, exonerate, and prosecute.
And we also have a lot of victims in sex trafficking cases and DV cases where the victim is reluctant to testify out of fear for her own life. I think especially in those cases, evidence stored on smartphones is particularly important.
Thank you. Where does the phone go after Apple has pulled data by way of a search warrant?
That's it. So I'll sort of walk through the process. If New York Police Department makes an arrest and secures a device, we then take that device, go to a judge with an application and ask for a search warrant. She then signs off as a judge. That piece of paper signed by the judge, the warrant, and the unlock order, then the phone and the papers go to California. Apple receives the phone, takes it in, and only its engineers are the ones touching the phone. What we receive back as a law enforcement institution is the data from that device. The phone itself comes back into the judge's possession, because remember, it's always the judge's, and that piece of evidence is in the judge's possession, and she or he determines exactly what to do with it. And that might mean it goes back into the police inventory. It might be later released. It's all depending on what the judge desires.
Okay. What information in the iCloud is never accessible by way of a search warrant?
It's never accessible?
Yes. So you can never get.
Well, I can say right now, even on iMessages, when we do a cloud search warrant, it's all encrypted. So in truth, I'm not getting anything related to important communications content. There may be some information that I do receive related to photos, and those are helpful. No one's here trying, we recognize that, for example, in the cloud, I might be able to get something that's useful out of a photo, and that's great. But in the end, as professionals in the law enforcement field, what we know is important for judges and grand jurors and other jurors to see is, what did people say? What did the text messages actually say? We have a fairly high burden. We want to do justice in every case, and what's critical is that whatever the information is, good, bad, indifferent, whatever, the content needs to be available. And if that helps us exonerate someone, that's a tremendous victory for justice. Just in the same way that if we're able to better prosecute somebody, that's a tremendous. So it's truly an access question right now.
Is your office able to keep the 200-plus phones in the hopes that you one day will be able to access the information on it?
That's right. Until a judge orders a release of those phones on a particular case, but that judge on all of those devices has signed off saying that Apple should turn over the information on that device. So they've already done the balancing of the competing interests, privacy and law enforcement's need to access the device. So we will hold on to the phones in the hope that that there's a solution down the road someday. Our victims are patiently waiting on a lot of these cases to try to get to an answer. Miss Mills in Louisiana, the mother of the 26-year-old who was killed, she's patiently hoping and asking Apple for a solution. So the phones are there, ready to be used anytime we can get to one.
Well, that seems to be the end of our questions for this afternoon. I want to thank our audience for sending such great questions, and I also want to thank again our presenters, Ken and Diem, for a very interesting conversation and basically overview of this issue. Thank you again for being on the National Center for Victims of Crime webinar, and I hope you attend our next one. Thank you very much.
Thank you so much for the opportunity to speak with you, and if anyone is interested in more information or updates on this, please visit our website at manhattanda.org/smartphone-encryption.
Thank you very much.
Thank you, Mai.